In January 2016, Meegan Vanderburgh was drunk driving when she rear-ended a pickup truck stopped at an intersection, allowing pedestrians to pass. The pickup truck was hit with enough force that it jerked forward and killed one of the pedestrians. The pedestrian crossed the road illegally and may have been impaired, but this was not an unforeseeable superseding act. Ms. Camyn was crushed by the pickup and sadly passed away within 24 hours of the accident. The state charged and convicted Ms. Vanderburgh with vehicular homicide, and she was sentenced to 8.5 years. She attempted to admit Ms. Camyn's toxicology report before and during the trial, and those requests were denied, as there was potential to cause a prejudicial outcome. Ms. Vanderburgh appealed her conviction, arguing the toxicology report should have been admitted and subsequent instructions to the jury should have included reference to this potential superseding cause. Let's get it started.
Good morning. It looks like we are ready to go on the only case on this morning's calendar, which is State versus Meegan Michelle Vanderburgh. Thank you for appearing today. I'm glad to see you here, Mr. Curtis, and that we could reschedule this case without much delay. Mr. Curtis, I'm sure that you are aware of how our time system works. Let me know when you begin your argument how much time you would like for rebuttal. Note that our clock just ticks down. So if you, for example, want 5 minutes of rebuttal, it will just tick down to 0. You can speak into your rebuttal and just lose it. So keep track of it. The middle light, though, will go on once you're into your rebuttal time. So please introduce yourself and let us know how much time you would like for rebuttal. And you are on mute.
All right, is that coming through?
Yes, thank you.
I apologize. Thank you. Kevin Curtis on behalf of appellant Meegan Vanderburgh. Your Honor, I'd like to reserve 5 minutes for rebuttal.
Very well, thank you. You can begin.
Oh, thank you. I thought Mr. Steinmetz was going to be introduced. So may it please the court and counsel, thank you for your accommodation and rescheduling this. I had a case of vertigo that I've never had before. But regardless, we are here. In this case, the trial court committed reversible error in 3 fashions that I'm going to discuss. I'm going to rest on the pleadings on the 2 arguments relating to sentencing issues. But the 3 areas the court committed reversible error are in the evidentiary rulings, the failure to admit the toxicology report of Ms. Camyn, and then the basis and method in which the impairment or possible impairment of Ms. Camyn was presented to the jury or prevented from being presented to the jury during a majority of the trial.
Mr. Curtis, I do have a question. With respect to the jury instructions, do you agree that the jury instructions in this case are substantially the same as the ones the Supreme Court approved of in Imokawa?
I'm sorry, Your Honor. Yes, I am waiving the jury instructions as it relates to that constitutional argument that was decided against us. So the jury instruction arguments I'll be making relate to the rules of the road, the civil instructions as to drivers at fault, basically in rear end accidents.
Thank you.
And then the third grounds is the cumulative effect of the toxicology denial, the jury instructions, and the method, again, in which the defense was not allowed to properly present their theory of their case from the beginning. Ms. Camyn's toxicology report was relevant. The trial court conceded it was relevant. The state conceded before trial and during trial. There were factual issues regarding causation. They withdrew their motion in limine that had been argued prior to the trial, attempting to exclude that evidence, and they voluntarily withdrew it and specifically stated and conceded factual issues existed that the jury needed to hear. The relevancy, again, is undisputed.
Mr. Curtis, I do have some concerns about the relevancy. I don't know that it's been conceded on appeal, at least. When this statute first was interpreted by the courts, the Supreme Court had indicated there needed to be a connection between the defendant's impairment and the accident. And the legislature changed the statute, and now it's quite clear that there needs to be no connection between the defendant's impairment and the accident. All you need to have is the defendant driving. And in fact, there's some language in the case law that the driving could be flawless. And as long as there's no intervening sort of force between the defendant's act of driving and the injuries, there's absolute liability under the negligent homicide statute. That's how I'm reading the law. Am I incorrect?
I believe so, Your Honor, and I think it's an area that the state argued extensively that this was a strict liability statute and the wrongful conduct is merely driving under the influence. And as such, there does not have to be, this goes into the civil instructions, frankly. And
well, I think that if there's
that strict liability
I think of it more as absolute liability than strict liability, because what it encompasses is that the state doesn't have to show negligence. All they have to show is that the defendant was drunk or impaired and that there was no intervening force between the act of driving and the injury. So there has to be some sort of unforeseeable intervening force such that the person would have been injured anyway, even if the defendant wasn't driving. So that's, and if that's true, why is it relevant that the injured person also engaged in misconduct, unless that misconduct was an intervening force, such as perhaps someone jumping out into the road? I could see, for example, if the driver of the pickup truck was impaired and you were representing him, then I could see that there would be an intervening act. He may be impaired. He doesn't do anything wrong. He stops and he is stopped for her. So luckily, he's drunk, but he stops for her, and then someone hits him from behind. That would be an intervening force that he didn't contribute to. But how is this an intervening force case?
Well, Your Honor, as to the first premise, and I see my time is already up for my, I still have a couple minutes. In two bases, I disagree with the premise that there's absolute liability. That there was language, dicta, that was picked up, and then that was specifically rejected in State v. Birch, in which it said, and it left this gray area as to whether innocent conduct could satisfy the prong for proximate cause in a DWI case. And they basically said there may be very few incidents in which there is innocent conduct, but they rejected the absolute liability and stated there could be circumstances in which innocent conduct occurred, and as such, that would prevent proximate cause and thus prevent the state from being able to prove an element. So the Supreme Court has not ruled that the driving under the influence itself causes it. It's not a DWI trial. There has to be the proximate cause. And then as to the intervening superseding cause, even notwithstanding that, if you accepted the state's proposition, then Ms. Camyn's conduct and whether that was foreseeable still is a causation issue for the jury. It could be an intervening superseding cause.
Are you saying it's more of a negligence standard, that as long as she was impaired, but objectively speaking, her driving of the vehicle was not negligent, that she has a defense? Is that what you're advocating?
Well, I don't even think you have to, not negligent. If she is not at fault, if she was not at fault for the initial collision, she is not the proximate cause of Ms. Camyn's death.
Well,
you can't have innocent driving conduct resulting in a conviction.
But I guess I want to dig a little bit deeper. Why isn't she at fault? Is it because objectively speaking, her driving was not negligent, or why is she not at fault?
Yeah, exactly. Is that still, I mean, as the court is aware, the statute was changed. There used to have to be a causal link between the impairment and the accident. And the Supreme Court said you don't have to have the causal link anymore, but you still have to have proximate causation. The state argued all we have to show is they were impaired and that their driving was, quote, the proximate cause. And Birch rejected that and said innocent conduct while driving does not fall under that province. It is not strict liability. Otherwise, again, it would simply be a DWI trial. So yes, our argument, and that's where it goes to both causation and to the jury instructions, is the jury had the right to at least consider that if she was not at fault in the rear end accident because of the instructions that provide an emergency doctrine defense and that our expert testified was present at the time, if she was not at fault and her driving was, quote, innocent conduct, proximate cause as a matter of law cannot be determined. They would have had to return a not guilty verdict, or even if they had a reasonable doubt about that, they would have had to return a verdict of not guilty. I hope I've answered the first question.
Birch was a Court of Appeals case. There is Supreme Court precedent saying it is strict liability or absolute liability, but your position is that that was dicta and that Birch overruled that dicta essentially?
Well, I think they delved deeper into the dicta, and I think there was another case. I want to say State versus Rivera. I could be wrong on that, but the Supreme Court has never come out and made that ruling. The state and the prosecutors have been arguing that for some time, and they've been arguing that that's what the legislation in effect did, but the Supreme Court has never specifically adopted that. They've never found in every case that you're looking at under which this issue has even addressed itself, there has been wrongful conduct in the driving, even under the DWI prong. Under Rogenkamp, they're driving a motorcycle 70 and a 35. In the Hirsch case, they drift off the road, they hit a guardrail, they come across the roadway, hit a Jersey barrier. In Meegan's, they're making an illegal left turn in front of a vehicle. In Near, they're driving 70 to 90 and a 35. Groback, State v. David, Souther, Buttsby, United States, all of these DWI impairment cases involved wrongful conduct driving of at least at fault, whether it was even an infraction. And in this case, if there's not even an infraction, we don't believe there can be proximate cause. You can't have innocent conduct. That would be unconstitutional.
Of course, driving drunk, the struggle is that driving drunk is not innocent conduct. But I understand. Do you want to reserve the rest of your rebuttal time?
Right. I do, Your Honor. And I would just comment that I agree that driving under the influence is wrongful conduct. But driving under the influence and not committing any type of traffic infraction, then it negates being the proximate cause of the accident.
Understood. Thank you. Mr. Simons.
Yes, I would reserve it.
Thank you. Mr. Simons.
And good morning to the court and good morning, counsel. And may it please the court, for the record, my name is Larry Steinmetz. I represent the respondent state of Washington. With respect to the trial court's ruling regarding ingestion of drugs by Ms. Camyn, the court had a tenable basis for its ruling. This is an abuse of discretion standard. And I would disagree with Mr. Curtis. The state did argue against introduction of that evidence at the time of trial. The trial court found that evidence, quote, was quite slim regarding its probative value. And if it was probative, that it was substantially outweighed by the prejudice. Our Supreme Court and divisions of this court have found that ingestion of drugs, evidence of that at the time of trial is highly or unduly prejudicial. And in only certain circumstances are parties allowed to bring that type of evidence into court, none of which are present here. For instance, if a witness testifies who's under the influence when they observed an incident and are testifying to it, or a witness is under the influence at the time he or she testifies, or with regard to a diminished capacity defense, the defendant can bring in his or her own ingestion of drugs or alcohol. The defense has not provided the court with any authority that a victim's state of mind or any potential ingestion of drugs where there's no evidence that Ms. Camyn was impaired is relevant in this case. certainly
You've heard when I articulated what my understanding of the absolute liability standard is. Do you think that that is correct, or do you think that there's a nuance? Mr. Curtis indicates cases such as Birch do not recognize strict liability, although I have to say I just pulled up Birch. The final wording is, after analyzing it, it says there's one single conclusion: the trial court did not err by instructing the jury that it could convict Birch without finding ordinary negligence or any other culpable mental state. So that seems to be the holding of Birch, though it is Division 2, not binding on us.
That's correct, Your Honor. A couple thoughts about that. One, the defense was able to argue regarding Ms. Camyn's conduct before she entered the intersection and while she was in the intersection. They argued she assumed the risk that she went into the intersection, that she lagged too long in the intersection, and that she had no right to be in the intersection. With regard to the proposed 3 jury instructions, civil instructions that defense proposed, it's our position that those instructions were misleading. Not that I'm not alleging Mr. Curtis was misleading. I want to be clear about that, but the instructions proposed were misleading and incomplete. I did provide the court with the additional instructions, which should have been given, at least in this case, if the court had accepted and given the 3 proposed defense instructions. Under WIPI 70.03, it states a pedestrian within a crosswalk has a right to assume that all drivers approaching will yield the right of way. That was not given. Another instruction, 70.0301, states that a driver of a vehicle approaching a crosswalk has a continuous duty of observation. 70.0302 states the driver of an approaching vehicle shall stop and remain stopped to allow a pedestrian to cross the roadway within a crosswalk when the pedestrian is upon the roadway. The final instruction, which wasn't given, is that no person shall drive a vehicle at a speed greater than is reasonable and prudent under the conditions, having regard to the actual and potential hazards then existing. The driver shall control speed to avoid colliding with others who are complying with the law. Now, if those instructions had been given, the jury certainly could have assumed that Mr. Nesdahl, who was lawfully stopped to allow Ms. Camyn and her partner to cross the roadway, that he did nothing wrong. And I would dispute that Ms. Vanderburgh's conduct, notwithstanding her intoxication, was innocent. It can't be disputed she was traveling too fast for the conditions.
But do we really need to go there, Mr. Steinmetz?
No.
I just have a hard time understanding in this case why the victim's conduct or misconduct was particularly relevant. Again, if she had run out into traffic unexpectedly, then maybe she would be a superseding force. But it seems like our case law that says that if all that exists is concurrent proximate cause, that evidence of concurrent proximate cause is not relevant. And there is a danger that the jury could misunderstand and think that contributory negligence is a defense, even though they're not instructed on it.
And I would agree with that, Your Honor. In Rogencamp, our high court stated that if a victim's conduct at most is a concurrent cause, then he or her, that their conduct is irrelevant with regard to a vehicular homicide prosecution. The defense here had to establish either that Ms. Camyn's conduct or someone else at that intersection, that their conduct was a superseding intervening event, which the courts have explained is a later event after the defendant's conduct has taken place, or the defense had to establish that Ms. Camyn or another's conduct was the sole cause of the collision and death. At most, you have here a concurrent cause, and that was argued to the jury. In fact, defense argued that her conduct was the sole superseding cause, which she caused her own death. So quite frankly, whether or not Ms. Vanderburgh was negligent is not an issue here. And certainly defense cannot argue that her conduct was incident, especially in light of the other instructions which weren't given. And the other instructions certainly put a different light on defense counsel's proposed instructions. Essentially, the driver has a duty to watch, always watch, for pedestrians and drive at a speed they can safely stop, and to allow a pedestrian to cross a roadway, whether or not they were lawfully or unlawfully in the roadway. But for the example you gave, Your Honor, with respect to someone jumping out in the road. Now that certainly is a different circumstance than we have here, but maybe in those circumstances, those instructions would be relevant. And these three instructions were considered by Division II and brought back. I provided that authority in my brief and rejected by that court, because that court found that the instructions as proposed by the defense in that case, it made it unclear to the jury as to whether or not a contributing cause could be a defense, and it's not. So does the court have any other questions on that?
I do not.
And again, with regard to Ms. Camyn's ingestion level, there was no evidence given pre-trial or at the time of trial that she was impaired. The medical examiner testified that those amount of drugs in her system are highly variable, and he could not conclude one way or the other whether or not she was impaired. And the toxicologist testified that those levels could have been medicinal at a medicinal level, and she could not form an opinion that Ms. Camyn was impaired.
I don't know how relevant it is, Mr. Steinman, but I wasn't aware of medicinal levels of methamphetamine. Is there are medicinal levels of methamphetamine?
Yes, Your Honor.
Okay.
It is prescribed, and there simply was no evidence in this case that whether or not she took the medications unlawfully or lawfully. But even if she did take them unlawfully, there's no evidence she was impaired. In fact, she was alert enough to notify Mr. Nesdahl that she was in the intersection and was crossing. So, quite frankly, that evidence would have only put the state on an uphill battle, because once you introduce that someone uses amphetamine or methamphetamine, that puts a person in a whole new light in front of a jury. And the trial court did not abuse its discretion when it excluded that evidence. It certainly didn't exclude Ms. Camyn's conduct in the intersection, and defense argued that extenuously during and at the time of trial. Thank you. And I have nothing further.
Okay. Thank you, Mr. Steinmetz. Mr. Curtis.
Thank you. While most evidentiary rulings can be an abuse of discretion, when the defense is not entitled to argue their theory of the case, it's a constitutional review and it's de novo, and that's what happened here. To suggest that there was, quote, no evidence of impairment of Ms. Camyn and that there was no existence of the amount of
Mr. Curtis, I'm going to
drugs
stop just a second.
Yes.
It looks like our clock is not working. If the bailiff could start our clock.
I thought I was just getting some extra time. Thank you.
I was standing still, Mr. Curtis. Go ahead.
3 expert witnesses testified that her meth level, even if it's rarely prescribed, was up to 5 times over the normal range. Meth causes erratic behavior, paranoia, impaired judgment. She had opiates.
Mr.
Yes.
Kirk,
Yes.
what does it matter whether the victim here was impaired while she was in the intersection or whether she was totally sober? The fact is she was where she was, and whether she was impaired or not didn't, how did that contribute, or how is that a defense, I should say?
Right. And I agree. I was going to get to that. Why? And that's why the factual disputes are so critical. The state's own investigator said not she wasn't a concurrent cause, she was a proximate cause. So we've already gotten over that hurdle from the state themselves. And he said it was because of her conduct entering the intersection, but also her conduct in the intersection. She may have been in there as long as 1 minute and 32 seconds when she had more than ample time. That's 3 times as much time as she needed to get through it. You had testimony from the passenger of the car that once Mr. Nesdal's vehicle came to a stop, that she stopped. Mr. Branda continued to walk, got across the intersection. He doesn't know what happened to Miss Camyn because they're walking side by side, but she stopped. She started yelling at the car as if the car was at fault, and she thought she had right of way. When you're in 1 minute 32, this isn't mere jaywalking. There was, whether she entered on a green light or whether she entered on a red was a question of fact. How long Mr. Nesdal was stopped was a question of fact. She was exhibiting erratic behavior. There was evidence of that, and there was evidence from the medical examiner, from the toxicologist, and from the detective that all of these types of behavior can be affected by these level of drugs. They were active drugs, which means they had been taken that day. They were active in the system. They had been ingested with the knowledge. And the state wants to get that out.
Didn't you get all the evidence of her behavior before the jury? Yeah, you didn't get the fact that she was impaired, even though I think she was allowed to, it was allowed to be referred to her as a possibly impaired person. But you got all the evidence in as far as what she did, how long it took for her to get across the intersection, her reactions, and all this matter. Why isn't this a proper exercise of discretion when it's just focused on the drugs she had in her system? And in other words, what she did was all before the jury.
Well, yes and no, Your Honor. First of all, we weren't even able to discuss any potential impairment till the end of the state's case. So we couldn't put that in front of the jury. We couldn't open with the theme. We couldn't close with it. Secondly, while we could put in certain conduct, the state disputed that conduct. They put other evidence in and say, no, that didn't happen. She's just jaywalking. So the question is it the defense theory of the facts or the state theory of the facts? Which one is true? So the question is, if they know that she has these substances that cause slowed mental processes, slow speech, sleepy behavior, erratic behavior, impaired judgment, are they going to, is that relevant to them in determining what set of facts are true, not the theory? We got to argue a theory. We didn't get to argue the facts. If they had said, I mean, the state even argued in their brief, you know, her ingestion of drugs, if any. Well, if any, we know what her ingestion of drugs was. They said you can't.
Wasn't she impaired? Wasn't she impaired before the accident? She was impaired before the collision. She was probably even impaired before your client started driving. So why wouldn't that be a concurrent cause rather than a superseding cause?
If her conduct was consistent with getting across the intersection in the amount of time, not stopping and yelling at a car, is that foreseeable when they've been in the intersection for over 1.5 minutes, when there's 24 seconds to get across, when the other individual is clearly able to get across with no problems? The jury is entitled to hear that evidence. They're entitled to hear, as the detective even said, that her conduct in the crosswalk was potentially a proximate cause, but you couldn't link it with why she was doing that, or if she truly was doing that. The jury wasn't given that information to make that determination. That causation issue, was she a proximate cause or the proximate cause? And they weren't given this information to be able to make that decision. And that's a factual question from the jury. Once you have irrational conduct that is that all 3 state experts testified is consistent with drugs. And I want to argue, the state got to argue Ms. Vanderburgh's combination of alcohol and marijuana, and the toxicologist testified, well, you know, yes, she's affected by the marijuana, and that gets in, even though when they testify that these other drugs have effects, Ms. Camyn's doesn't get in because the judge says that you couldn't determine with reasonable certainty what individual effect it had on Ms. Camyn. That was the grounds for excluding.
Mr. Curtis, you have gone over on your time, but we very much appreciate your arguments. We appreciate you being here today. It's nice to see everyone. This case is submitted and the court will be in recess. Be well. Thank you.
Following these arguments, the trial court's findings were affirmed. The court found that the trial court did not err by rejecting the toxicology report from evidence. It was irrelevant. As such, the judge's instructions to the jury were also appropriate. And there you have it, folks. In my opinion, the only error here is the minuscule 8-year sentence for taking someone's life while drunk driving. Stay safe and let me know what you think in the comments below.